A judge just threatened to put a former president in jail. Not a hypothetical. Not political theater happening somewhere far away in some theoretical future. This is happening right now in real time in a courtroom in New York City, and the consequences will echo through the 2024 election and far beyond it. Justice Juan Merchan delivered a direct ultimatum to Donald Trump: stop violating the gag order that the court imposed, or face criminal contempt charges that could result in actual imprisonment. This development changes everything about how we understand this case, this trial, and this moment in American history. I need you to understand exactly what happened, why it happened, what it means for the legal system, and what comes next. This is the most significant courtroom development in modern American political history, and I'm going to walk you through every dimension of it with the depth and clarity you deserve. Let me start with the immediate trigger. Justice Merchan did not issue this warning in a casual or ambiguous manner. According to court records and reporting from legal correspondents inside the courtroom, the judge delivered a pointed and explicit statement making clear that Trump's repeated violations of the court's gag order had pushed him dangerously close to a finding of criminal contempt. The warning was not a gesture, not a procedural formality, and not a signal designed to be negotiated away. It was a red line drawn in ink, and everyone in that courtroom understood exactly what it meant. The implications for the former president, for his ongoing criminal trial, and for the broader American legal system cannot be overstated. We are in genuinely uncharted territory here, and every development from this point forward carries weight that our institutions were not necessarily designed to bear. To understand why this moment matters so profoundly, we need to step back and examine what a gag order actually means within the American justice system. This is important because most coverage of this story has glossed over the fundamental mechanics of what is actually at stake. A gag order in a criminal case is not some minor courtroom rule that judges hand out like parking tickets to defendants who annoy them. It is a serious and constitutionally sensitive restriction on speech that courts impose only when they determine that public statements from any party could reasonably prejudice the jury pool, intimidate witnesses, or interfere with the administration of justice. The standard for issuing such an order is deliberately high because the First Amendment stands as a constitutionally protected barrier against government censorship. And courts understand that restricting speech, even speech we might find distasteful or dangerous, requires compelling justification. When Justice Merchan issued his gag order in this case, he did so because he recognized that Trump's public statements about witnesses, prosecutors, and even members of his own jury pool had created genuine documented risks to the trial's integrity. Think about that for a moment. The judge did not impose this restriction lightly, and the fact that he has been forced to reinforce it repeatedly across multiple sessions speaks to a pattern of behavior that has pushed the legal system to its absolute limits. Now, let me be precise about what the violations actually entailed, because this matters enormously for understanding the gravity of what just happened. Court records document at least 10 separate and distinct instances where Trump made public statements that directly contravened the gag order's clear prohibitions. These were not ambiguous comments accidentally caught in some technical violation of complex legal language. These were targeted, deliberate, and in some cases repeated attacks on specific witnesses who are scheduled to testify against him. These were named assaults on the prosecution team, including direct attacks on the lead prosecutor. And in at least one documented instance, Trump's public statements ventured into territory that multiple legal experts have described as hovering dangerously close to implicit jury tampering. Each individual violation gave Trump's defense team grounds to petition for a mistrial based on prejudice to the defendant. Each one created potential grounds for appeal if Trump is ultimately convicted. And each one demonstrated a deliberate and consistent willingness to test the absolute boundaries of what a court will tolerate from a defendant, any defendant, but particularly one who wields the microphone of a former presidency and commands a media apparatus that can amplify any statement to millions of people within minutes. Justice Merchan's patience has now apparently reached its absolute limit, and the warning he delivered carried the unmistakable weight of someone prepared to follow through on consequences that no judge has ever imposed on a major party's presidential nominee in the modern era of American politics. Let me explain exactly what the contempt of court charge now looming over Trump's head actually means, because this is where the stakes become almost surreal in their magnitude. Under New York state law, criminal contempt can carry a sentence of up to 30 days in jail for each individual violation that the court determines was willful. If the court finds that Trump committed multiple willful violations of the gag order, those sentences can stack, meaning the former president could theoretically face weeks or even months in a jail cell, while simultaneously running a presidential campaign for the highest office in the land. Let me say that again so it fully lands. Donald Trump could be incarcerated, physically held in a jail cell, while actively campaigning to return to the White House. That scenario sounds almost too dramatic to be real, which is precisely why it has captured the complete attention of legal scholars, political strategists, constitutional experts, and ordinary citizens who never imagined they would witness such a moment in American democracy. The question of whether a candidate for President of the United States can be imprisoned while seeking that office has no clear precedent in American constitutional law, and the implications spiral outward in every conceivable direction. Now, before we go any further into the legal mechanics, let me establish the broader context that makes this moment so historically consequential. This criminal trial is not happening in isolation. It is one of 4 separate criminal cases pending against Donald Trump across federal and state jurisdictions. The New York case centers on allegations that Trump falsified business records to conceal hush money payments to adult film actress Stormy Daniels in the final weeks of the 2016 presidential campaign. Prosecutors argue that these falsifications constituted campaign finance violations that rose to the level of criminal conduct punishable under New York law. Trump's defense team maintains with absolute consistency that the payments were purely personal matters, with no connection to campaign finance law, and that the case is politically motivated persecution designed to prevent him from retaking the presidency. Whatever your political views happen to be, recognize this fundamental fact. A former president of the United States is standing trial on criminal charges for the first time in American history. The outcome of this case will establish precedent that shapes every future question about presidential accountability, and the judge's willingness to enforce his orders despite the extraordinary political sensitivity of the defendant sends a profoundly important signal about the independence of the judiciary in America. The political ramifications of any contempt finding or actual imprisonment order extend far beyond the walls of that courtroom. Trump's legal and political team has already signaled their strategic approach to any adverse ruling. Use it as evidence of political persecution to be wielded before the electorate and the base of supporters who already believe the legal cases against Trump are illegitimate partisan attacks designed to prevent him from returning to power. This narrative has proven remarkably effective at mobilizing his base across multiple election cycles, and polling data consistently shows that a substantial portion of the Republican electorate views the criminal cases against Trump as precisely that kind of coordinated persecution rather than legitimate law enforcement. This perception creates a dangerous and self-reinforcing feedback loop, where any punitive action taken by the courts can be immediately reframed as proof of the very corruption they claim does not exist, and that reframing drives turnout, fundraising, and political energy in ways that are genuinely difficult to counteract through factual counterargument alone. The prosecutors navigating this minefield understand that they must achieve convictions based on evidence so overwhelmingly clear that no amount of political spin can obscure it. They must maintain the procedural integrity that will allow those convictions to survive the inevitable and extensive appellate process that will follow any guilty verdict. And they must do all of this while operating under the most intense public scrutiny and political pressure that any prosecution team has ever faced in American history. Now let me go deeper on the institutional dynamics at play here, because this is where most coverage of this story falls tragically short. The judiciary in the American system operates independently of the executive branch by explicit constitutional design, and that independence becomes most visible and most tested exactly in moments when powerful figures face genuine legal consequences. Justice Juan Merchan has been subjected to relentless personal attacks from Donald Trump over the course of this trial, including repeated public descriptions of the judge as a biased actor with political motivations and connections to the Democratic Party. Trump's social media posts have generated documented harassment campaigns against members of the judge's family who have absolutely nothing to do with the case and who never asked to be dragged into political warfare. Despite this sustained and extraordinary pressure, Justice Merchan has continued to preside over the proceedings with apparent impartiality, maintaining the same rules and standards that would apply to any defendant in his courtroom, regardless of their status, their wealth, their political power, or the size of their media following. That consistency and institutional resolve matters more than most people realize or appreciate. It represents the kind of quiet, unglamorous strength that democratic institutions require from those who occupy positions of authority within them. When judges crack under political pressure, when they allow the identity of the defendant to influence their rulings, when they treat powerful figures differently from ordinary citizens, the entire foundation of democratic legitimacy crumbles. What we are watching in Justice Merchan's conduct is the institutional integrity of the American justice system, being demonstrated under the most extreme stress test it has faced in at least a generation. Critics of the prosecution in this and other cases have raised legitimate and serious questions about the unprecedented nature of charging a former president with crimes that allegedly occurred before he took office or after he left it. Some legal scholars, including some who have spent careers studying constitutional structure and the separation of powers, argue that criminal prosecution of former presidents sets a dangerous precedent that could eventually be weaponized against future presidents from either political party. They worry that transforming political competition into a battlefield of criminal charges and countercharges would fundamentally undermine the democratic process by replacing electoral competition with judicial combat, turning courts into weapons of political warfare rather than impartial arbiters of legal disputes. These concerns deserve serious and honest engagement, and the fact that thoughtful, nonpartisan legal scholars disagree about the proper scope of criminal liability for former executives reflects genuine constitutional uncertainty about how institutions designed centuries ago should function in the modern political landscape. However, the counterargument carries equal weight and deserves equally serious consideration. Here is what critics of prosecution sometimes miss when they focus exclusively on precedent concerns. If the governing standard is simply that charging a former president creates bad precedent that must be avoided regardless of the alleged conduct, then no former president can ever be held accountable for anything under criminal law. The logic of that outcome is worse than the precedent it would supposedly avoid, because it creates a permanent class of individuals who are immune from legal consequences simply because they once held a particular office. That outcome contradicts the foundational premise of American democracy, which is that no one, regardless of how much power they hold or how recently they held it, stands above the law. The question isn't whether prosecution is always appropriate in every circumstance. The question is whether alleged crimes are serious enough to warrant it, and whether the evidence supports conviction beyond a reasonable doubt. Those are precisely the questions that courts exist to answer, not political operatives or partisan commentators. Now, here is something that most viewers and casual followers of this story have not fully considered, and it is critical to understanding the full scope of what we are witnessing. This trial, as consequential as it is, represents just one front in a multi-front legal battle that is unprecedented in American history. We have the New York case involving business record falsification and alleged campaign finance violations. We have the federal case in Florida concerning classified documents that Trump is accused of retaining illegally after leaving office. We have the federal case in Washington, D.C. concerning efforts to overturn the results of the 2020 presidential election and the events surrounding January 6th. And we have the Georgia case involving alleged election interference in the state's 2020 election results. Each of these cases involves different facts, different legal theories, different prosecutors, and different potential outcomes and sentences. But they all share one essential characteristic. They collectively test whether American legal institutions can hold the most powerful figures accountable for their actions without collapsing under the weight of political pressure. No individual case should be viewed in isolation. The pattern they form, taken together, represents the most comprehensive accountability challenge any democracy has faced in the modern era, and the outcome will reshape how we understand the relationship between power, law, and democratic governance for decades to come. The human dimensions of this trial deserve sustained attention because justice is not an abstract concept that exists only in legal textbooks and academic treatises. It is a lived experience that shapes how ordinary people relate to the government that claims authority over their lives. Witnesses who have testified or who will testify in the coming weeks and months have described the experience of receiving threats and harassment connected to their involvement in this case. The women at the center of the hush money allegations have faced decades of personal attacks, public scrutiny, and professional disruption that no ordinary citizen should be expected to endure simply for having been involved in a private transaction. The jurors who were selected to hear this case have been forced to sacrifice weeks of their lives, disrupt their employment, and expose their families to the intense media attention, and in some cases explicit threats from people who oppose the proceedings and view the jurors as complicit in what they describe as political persecution. These human costs matter enormously, and they are not abstractions. When the legal system works as intended, it provides accountability and protection for ordinary citizens against powerful interests. When it fails, whether through bias, corruption, or simple inability to function under pressure, it leaves scars that compound across generations and erode the trust that democratic governance requires to function. Now let me connect this to something bigger that most mainstream coverage has almost entirely missed, and this point deserves your full attention. America has long presented itself to the world as a model for the rule of law, arguing that stable democracy requires independent courts, equal application of legal standards, and genuine accountability for those who wield power. Critics of American foreign policy and domestic practices have frequently, and with considerable justification, pointed to apparent inconsistencies between these stated principles and actual practice as evidence of systemic hypocrisy. They have asked, often rightly, how America can claim to champion rule of law while maintaining structures that preserve power disparities, that allow economic elites to navigate legal consequences differently than ordinary citizens, and that have historically excluded large portions of the population from full participation in democratic processes. The outcome of this trial and the related cases against Trump will either reinforce or catastrophically undermine America's claim to represent a system where justice is genuinely blind and where legal accountability applies to everyone, including those at the very top of the power structure. In nations around the world where leaders face no meaningful consequences for abuses of power, where courts exist as instruments of political control rather than impartial dispute resolution, and where the powerful systematically escape accountability, while ordinary citizens bear the full weight of legal enforcement, the American example has historically carried weight precisely because it demonstrated that even the most powerful figures could be held responsible under the law. If that central demonstration fails, the global implications extend incomprehensibly far beyond the borders of a single country. Authoritarian regimes and their propagandists around the world will point to this moment and say with absolute confidence, even in America, even in the birthplace of modern democracy, the powerful are not actually held accountable. The rule of law is a myth that elites invoke when it suits them and discard when it does not. Why should we pretend to believe in it? That outcome would damage American soft power and democratic credibility for generations, and it would strengthen the hand of authoritarian movements everywhere that rely on cynicism about democracy to maintain their grip on power. Here is the central question that will determine everything about the coming months and years. Can democracy survive the stress test of holding its most powerful figures accountable for alleged crimes without descending into chaos, without becoming a weapon of partisan persecution, and without sacrificing the impartiality that makes courts worth trusting in the first place? The honest answer is that the outcome is not predetermined. It is not inevitable in either direction. It depends on the wisdom of judges like Justice Merchan, who must navigate uncharted procedural territory while maintaining institutional integrity. It depends on the integrity of prosecutors who are navigating unprecedented terrain without a map or precedent to guide them. It depends on the discipline of defense attorneys who are operating under extraordinary pressure from their client, their party, and the political movement that regards this prosecution as illegitimate by definition. It depends on the restraint of political operatives who benefit enormously from chaos and conflict, and who have every incentive to escalate rather than de-escalate. And ultimately, critically, it depends on the capacity of ordinary citizens like you to evaluate competing claims with rigorous critical thinking rather than reflexive tribal loyalty to political tribes that demand uncritical acceptance of their narrative, regardless of the facts. What happens in that New York courtroom will not only determine Trump's fate in this specific case, it will establish concrete, binding parameters for how all future American presidents can be held legally accountable for their actions, their conduct, and their decisions while in office and after leaving it. That responsibility deserves the most serious, clear-eyed, and honest attention we can possibly bring to it, because the stakes could not be higher and the consequences could not be broader. Let me walk you through the procedural next steps so that you understand exactly how this unfolds from here. If the court determines that Trump's violations of the gag order warrant contempt charges, Trump's defense attorneys will have the full and legitimate opportunity to contest that finding through formal legal proceedings, to present their own evidence and arguments about the nature and willfulness of the alleged violations, and ultimately to appeal any adverse ruling through the layered structure of the New York State court system. This entire process will take months, potentially years, and the profound constitutional questions at its center will eventually demand resolution by courts that have never addressed precisely this situation in American history. The American legal system has proven remarkably adaptable over more than 2 centuries of existence, finding ways to process novel challenges and unprecedented circumstances without collapsing under their weight. Whether it can successfully navigate this particular challenge depends entirely on the willingness of all participants to accept outcomes that may be politically disadvantageous to their preferred conclusions. Here is something that the mainstream coverage has almost entirely missed or deliberately avoided, and it is a question that demands serious consideration. What happens if Trump is convicted, sentenced to actual jail time, and then the question becomes whether that imprisonment legally prevents him from serving as president if he wins the 2024 election. The United States Constitution specifies the basic requirements for the presidency, including age, citizenship, and residency requirements, but it does not explicitly address whether incarceration disqualifies someone from serving as president if elected. Legal scholars and constitutional experts are already actively debating this precise question, and the intensity of that debate will intensify dramatically if we reach that scenario in real life. The political implications of that scenario are almost incomprehensible in their magnitude. Trump would immediately become the most potent possible martyr to his political base, a living symbol of government overreach that validates every complaint about political persecution that his supporters have ever made. The fundraising implications alone would be unprecedented in American political history. Meanwhile, his practical ability to actually campaign, to meet with voters, to participate in debates, and to conduct the normal activities of a presidential campaign would be severely and fundamentally limited, creating a dynamic that has never existed in American political history, where a major party's nominee operates from a jail cell or from house arrest while seeking the highest office in the land. How courts, how election officials, how partisan observers, and how ordinary voters would ultimately respond to that scenario is genuinely and completely unknown. There is no playbook. There is no precedent. There's only the capacity of our institutions to navigate a challenge they were not designed to handle. Let me step back and consider the broader pattern that has brought us to this moment, because understanding the pattern helps us understand what this moment represents. Trump's legal troubles represent the culmination of years of behavior that has consistently, almost systematically, pushed against institutional boundaries and legal constraints. From his business practices before entering politics, through his term in the White House and continuing into his post-presidency activities and his current campaign, there is a demonstrable and consistent pattern of testing limits, challenging established norms, treating legal restrictions as obstacles to be negotiated around rather than rules to be followed, and treating accountability as something to be avoided rather than accepted as the natural consequence of exercising power. This pattern matters enormously because it reveals something fundamental and important about the character of the person who is currently seeking to return to the presidency. Understanding his consistent relationship with legal constraints and institutional authority helps every voter evaluate honestly whether his return to power would represent a continuation and intensification of the same approach that produced these very violations and these very legal troubles, or whether something fundamentally different would emerge from a second term. That evaluation is ultimately one each citizen must make for themselves, but it can only be made honestly if we acknowledge the pattern clearly and completely. Here is what I want every viewer to take away from this entire breakdown, something that transcends the immediate legal mechanics and speaks to the deepest meaning of this moment. The stakes are genuinely historic in a way that has not been seen in American politics in at least a century, and arguably not since the founding era itself. We have genuinely never been here before as a nation. There is no reliable playbook. There is no historical guide. The institutions that will ultimately determine how this resolves are the same institutions that have defined American democracy and American identity for more than 2 centuries, and whether they prove adequate to this unprecedented challenge will shape the country that your children and your grandchildren will inherit. That sounds dramatic. It should sound dramatic. This is a dramatic moment in American history, and treating it with anything less than the seriousness it deserves would be a failure of honest analysis. For those who have followed this coverage from the beginning, thank you for staying engaged with a story that will define a generation's understanding of American justice and democratic accountability. The next phase of this trial promises developments that will test our institutions in ways we cannot fully predict or prepare for in advance. And informed, engaged citizens are the essential foundation of a democracy that actually functions as intended. Subscribe and enable notifications so that you can follow each critical development as it unfolds in the coming days and weeks. The story is far from over, and the final chapters have not yet been written. What comes next will matter more than what came before. Your continued attention to these proceedings matters more than you might realize in this moment. The survival of democratic institutions depends on citizens who refuse to look away when the moment demands everything they have. Democracy does not sustain itself automatically. It requires active, informed, committed participation from people who understand what is at stake and who choose to engage rather than retreat into comfortable disengagement. If this breakdown has helped you make sense of a genuinely complex situation, hit the like button as a signal to the platform's recommendation systems that content explaining institutional mechanics and legal accountability deserves wider distribution to people who need to understand these matters. The structure of American justice and the mechanisms of democratic accountability are things that every citizen in a self-governing society should understand clearly, and your engagement helps ensure that understanding reaches people who currently lack it. The question now is whether we as a society can meet this extraordinary moment with the wisdom, the institutional strength, the procedural integrity, and the civic commitment that it requires. The answer does not depend on judges alone, or prosecutors alone, or defense attorneys alone. It depends on all of us, on our collective willingness to demand accountability from those who wield power while preserving the impartiality that makes courts worth trusting. Thank you for giving this story the sustained attention it demands. Stay informed, stay engaged, stay committed to the hard work of democratic citizenship. And remember that your participation in this process, your willingness to engage honestly with difficult and consequential questions, is itself an act of preservation of everything that makes America worth defending and improving. The future is not written yet, and the choices we make together in moments like this one are what will determine what kind of country we hand to the next generation. The question is whether we meet this moment with everything it requires. The answer depends on all of us.